A very good afternoon, ladies and gentlemen. Thank you for joining this very interesting discussion this afternoon on time. We are going to give it 1 minute so that we can all get settled in. In the meantime, I would ask you to tell a friend that our session has started and will be starting in the next 1 minute. If you have a friend who is interested in this session that has not logged on, feel free to share the link with them and we'll send them the Zoom link for them to join this particular call this afternoon. That said, this afternoon we are thrilled to have you join us for what promises to be an enlightening and engaging session. As introduced, I'm Gabriel Achai, and the session will be hosted by my colleague, Miss Praise God, uh, Joseph. And today we have an exceptional panel of experts who have come to share their insights on the role of alternative dispute resolution in resolving business and human rights conflicts. Now, our panelists this afternoon have a diverse background and wealth of experience, and to that end, are poised to provide valuable perspectives that will inspire us all. And today, I encourage us to all engage actively. Please feel free to share your thoughts in the chat, ask questions, participate in the discussions, and let's have fun. We are streaming on Facebook, YouTube, and on Zoom. And ladies and gentlemen, without further ado, let me hand over to Praise God, Joseph Millen, who is our moderator for the day. Miss Praise God is a program officer at the Pan African Lawyers Union. She is a woman of many colors. If I started introducing her now, I do not think I would finish soon. So permit me to hand over to Praise. And Praise, we are all yours for the next 2 hours. But before you come on, colleagues, if you've not yet heard, the East Africa Law Society is having the largest gathering of construction law experts. And this is happening in Kigali, Rwanda, the land of 1,000 hills, starting from the 25th to the 27th of September. Please join these discussions if you're interested in matters to do with construction law, FIDIC, contract conditions, and come mingle, network with the industry leaders from across the region and grow your networking base as you also grow your intellectual prowess. That said, also for the first time in East Africa, the East Africa Law Society, in collaboration with the McGill University, is hosting the first ever International Space Law Masterclass that will be sitting in Nairobi, the Silicon Valley of Africa, on the 3rd to the 4th of October 2024 at the prestigious Emara Oresereni Hotel. Come join industry leaders across the globe and have a discussion on what space practice gets to offer you as a lawyer. If you want to register for any of these trainings, please visit our website or write to us at info@elawsociety.org. For now, I'll hand over to Praise. And Praise, sorry for eating into your time, but now is your time. Take us away.
Thank you, Gabriel, and thank you for the introduction. As introduced by Gabriel, my name is Praise God Millen Joseph. I'm a program officer working with Pan African Lawyers Union, and thank you all for joining this webinar for interaction. And we aim that this webinar can be as interactive as possible so as to ensure that we exchange discussion, practice, and experience across the East African region. And as the title speaks for itself, we want to understand how ADR is involved in resolving issues of business and human rights in the region. As most of us are used of the traditional means or mechanism, that is using of courts for litigation, we have seen that ADR, the alternative dispute resolution, is also one of the key avenues that we can use, especially on issues of business and human rights. And as stated, we have experts in this area who give us practical examples, practical experience on how ADR has been used effectively to resolve these disputes around business and human rights, and how communities have been able to receive the remedies that they have sought before as victims of this violation by different corporations. And to kickstart this discussion, we are going to start with our panelist, Mr. Cyrus Maweu, who is the Deputy Director of ECOSOC Division, Kenya National Commission on Human Rights. And he's going to give us the existence of ADR mechanism and how to access them effectively. So he's going to take us through understanding the role of ADR and how we can access it to resolve this dispute. Mr. Cyrus, welcome.
Thank you very much. Praise God. As already introduced, my name is Cyrus Mawe. I am currently on transition, and I wish to confirm that I'm a full-time student. I have taken leave of absence from the Kenya National Commission on Human Rights. Yeah, but it's a great opportunity to engage with all of you to discuss together. And I just go right into today's discussion. But allow me to first start by pointing out that access to remedy in and of itself is a right, and it's been widely acknowledged both locally and internationally that for every violation there must be a remedy. I've seen different constitutions, different legal frameworks provide for different remedies. A good example is our Kenyan constitution that even goes as far as identifying some of the remedies that can be provided for a violation and allowing or conferring the power on the courts to determine what would amount to an effective remedy. I've also seen in different cases where people are negotiating, be it an employer-employee relationship, be it a business community engagement, that at times they're even thinking through possible disputes, how to resolve them, and they provide for different mechanisms, others expressly going for alternative dispute resolution mechanisms, or broadly, alternative justice systems. So it's not everyone who goes to court, it's not everyone who has access to court, and one has a wide variety or a wide array of remedies that they can choose from. And if you look at the broader access to remedy framework under the United Nations Guiding Principles on Business and Human Rights, there is the role of the state, the role of the businesses, and access to remedy, which is expected to be a contribution by both the state and the businesses. And there is no binding obligation to prefer any one mode over the other, and the guiding principles are permissive enough to allow the businesses as well as the state to engage in different alternative dispute resolution mechanisms. With growth of business, and this is something that all the countries within East Africa have been very keen on, the ease of doing business, the constant rankings that we keep seeing. We are busy almost every now and then negotiating strategic trade and investment programs or agreements with different countries. And this comes with or brings with it a number of human rights ramifications. And key among them has been the concern for the safeguards for human rights as and when these violations occur. Most of the times they'll be outside the country and people may not easily access the justice mechanisms in those countries or back home. Think also of labor migration and the different challenges that it presents. So there's a wide variety of different alternative dispute resolution mechanisms. It's about one, identifying what would work for them, what they would be more comfortable with, what is more accessible to them. And I'll just run through a few of them. I hope I'll be able to share my screen. So I hope you can see this. As I had already pointed out, there are quite a number. So one is left to choose for themselves which way they want to go. And court remains an option because the courts would, at the end of the day, exist to hear any disputes, and access to the courts as a remedy mechanism is also something that is open to the different parties. But one has to weigh the different options. Is a court even physically accessible? Most of you might be aware of the challenges that present themselves when you go to the formal or the traditional legal systems. Whether they are legal systems or justice systems is debatable, but there are all those different issues that present themselves. So I've picked this quote from a former Chief Justice. He said this when he was opening a court. And this basically tells you that even the judges appreciate that they are not the only ones who are there to hear and determine disputes or provide access to remedy or access to justice, as it would be in each case. So he was encouraging people. I believe he was quoted out of context. He was not really encouraging people to go to witch doctors, but he was basically telling people that there are different alternatives. We don't all have to keep threatening each other that we need to meet in court, because that business of meeting in court is not always the most productive. So I've highlighted a number of different options that one can pick. Negotiations basically between two people where those who are conflicting can just negotiate as amongst themselves, and this is an option that is always available. For the Christians, the Bible is actually very clear on this. It promotes this kind of dispute resolution. It says expressly that if two people have a dispute, please talk amongst yourselves. If you cannot agree, bring in a third party, and that takes me to mediation, where you bring in a third party neutral. It further escalates it that you can also have the church involved. There are all these other people who are engaged in dispute resolution. We've also seen quite actively, especially in the context, in the Kenyan context, amongst indigenous communities, minorities, traditional dispute resolution mechanisms that are quite active, that are quite robust, that are trusted by the people, and the people are using them almost on a daily basis to resolve disputes. And sometimes they are calling upon those elders to resolve disputes that might have business and human rights component. We've also seen some businesses that have established grievance handling mechanisms at their operational levels. Kakuzi is an example in Kenya, amongst many others that are now currently engaged in the process of establishing dispute resolution or grievance handling mechanisms, moving beyond the complaints and suggestion boxes to looking at what are some of the concerns that the communities have and how best can they be resolved. Under the UNGP's framework, and for the countries that already have national action plans on business and human rights, states are encouraged to also consider and operationalize state-based non-judicial mechanisms. So as they strive to have the courts, as they hire the judges, as they equip the courts, they should equally focus on those who are finding their way into all these other alternatives. And it would shock you that a bigger fraction, actually, from a needs survey that was done in Kenya, Justice Needs Survey, more than 80% of the disputes are resolved outside the courts. So it begs the question, are these alternatives, or is this in a way becoming the mainstream? And if we were to do strategic investments as different countries, does indeed then make a lot of sense? Because there is empirical evidence, and this is where people are going, these are the avenues that they are resorting to. Does indeed then make a lot of sense to invest equally, if not more, in these other dispute resolution mechanisms? We also have arbitration, which is quite regulated, the manner of appointing the arbitrator, the sessions, how parties can agree with the arbitrator giving the final award, enforcement of that award, and to what extent the courts can interfere in an arbitral process. Is their role basically adopting and enforcing, or can they interfere, and to what extent? So that is quite regulated, unlike all these other alternative dispute resolution mechanisms. So allow me to more consciously focus on how best you can design an ADR mechanism that would address the needs of a community from a business and human rights perspective. And this would apply to whichever way you are looking at it, whether you are the corporate, whether you are the one advising the business on how they can go about operationalizing this, or whether you are the one advising the communities on how best they can advocate and support the development of a framework that can better address their needs. One of the things that you need to be alive to is the power dynamics between the corporate. Corporates are very powerful. Some of us might remember the time a former president of the US was complaining that he had literally been kicked out of Twitter. And that's basically to just demonstrate how powerful businesses can be, sometimes even more influential than the governments themselves. And they exert a lot of power and influence over both governments and communities. So it is good to be alive to these dynamics as you design the grievance mechanism that will come up with, or the ADR mechanism, whichever name you give it, that will come up with for purposes of assisting the communities in handling the disputes that might present themselves. The key other consideration is how functionally effective these mechanism will be. So at the back of your mind, always ask yourself, is what I'm designing fit for purpose? Will it serve the interest of both the community that is meant to interact with it, that is meant to use it, and will it also adequately serve the interest of the businesses? Guideline number 31 provides quite some critical guidance, and I'll be going through that in a short while. Some of the thoughts that I came up with is the importance of inclusion and participation of the communities. It is not wise to have a grievance mechanism that cannot serve the communities, or that the communities are not okay and are not comfortable using, because you just have a mechanism that does not serve any purpose for which it was intended. To ensure that the communities participate, there's a need for genuine consultation. Sometimes businesses and also the state, because the state is also in business, it can be considered business enterprise in certain aspects. They just consult to tick boxes, not really genuinely, not from a genuine desire to engage these communities. And then there is very little or no information on what is being set up, what it's meant to do, and what is in need for the community. So there's a need to share information before people participate in whatever mechanisms that are being designed. So the design, the implementation itself, and even the audit of the mechanism should be participatory, and the community should have a way of giving feedback for purposes of constantly improving these mechanisms. Again, alive to the power dynamics that I'd already spoken to, there's a need to be conscious that some sectors of the community may not participate as we may want them to participate because of different vulnerabilities. So we may go a step further, whether you are the one advising, or whether you are the one implementing, or whether you are the corporate that is spearheading all this. You may need to consciously target, especially the most vulnerable, where the indigenous people, seek them out, where women are not participating. It may warrant you having different sessions with them, hear from the trade unions, hear from the human rights defenders, and any other stakeholder who may have one or two concerns and who is expected to input into the process. Having a mechanism is one thing, having it function is another, and having it function effectively is another. So there's a need for regular audits, again with the participation of the communities, and you need to look at both the process itself, how accountable is it, how transparent is it, can people challenge, and where can they challenge, does it conform to what would ordinarily be considered justice in terms of the outcomes that it gives. You also need to be sensitive to the cultural dynamics between the different communities, and ensure that you also think through the enforcement mechanism, because this is meant to serve especially the most vulnerable who may not have the muscle to go to court and the muscle to take the big corporates through the litigation process. As I'd already pointed out, Principle number 31 of the UNGPs provides some guidance on what would amount to an effective grievance mechanism. It has to be legitimate, and this is the only way to build trust, and without trust, people will not be able to use it. So you need to think through that. It has to be accessible. Do people know it exists? How can they interact with it? Are the processes known to the communities or to the people who are supposed to interact with it? And this also takes me to the predictability, because people need to know if we submit ourselves to this mechanism, this is how it functions, this is how we are likely to be treated, and this is how to interact with the mechanism. It has to be equitable. Again, the provision of relevant information, I cannot overemphasize this. Transparency is very, very important. You don't want to, and most people will not submit themselves to a process that is not clear, that they don't know what is being done, and they should be kept informed of what is happening, especially where they have complained and where they have grievances that remain unaddressed. And one of the advantages of this kind of a process is that you are not strictly limited to the issue that has been presented or the complaint that needs to be addressed or the specific violation, but you can also project and look forward and see how best you can avoid some of these things from happening, as opposed to litigation where judges and magistrates sort of constrain themselves to the issue beforehand. And finally, this has to be rights compatible in terms of the outcome, the remedies that it provides. Do they conform to what we would otherwise consider notions of justice and fairness? I think I will stop at that, but before I wind up, allow me to just highlight the fact that it's been widely acknowledged world over that courts are not the only ones that render justice. In fact, and this I give credit to the Kenyan judiciary, they've accepted and embraced the role of promoting these other alternatives that people are using in their quest to access justice. Our current Chief Justice talks of the multi-door approaches to justice. And I think of courts as the hospital, where you only seek medical services where you are unwell. So by the time you're going to court, things have already gone worse. But if you resort to these other mechanisms, there's a high possibility that you can sort out most of the problems, and very little problems or very little of these grievances will present themselves or will finally find their way to the court. So let me stop at that. I will be happy at an opportune moment to provide clarification should the opportunity arise. Thank you, and back to you, Prisco.
Thank you so much, Cyrus, and thank you for keeping time. And that was quite insightful. And as you kickstarted, access to remedy is a right. And thank you for informing us that about 80%, as the statistics you have given us, show that most of the dispute settlement have been done outside, especially in areas of investment. And that's where the business sector is centered. And informing us how even the judiciary of Kenya has and is continuously engaging and promoting also the alternative dispute mechanism. And here is where we are going to welcome Mr. Joseph, who is the co-chair of the African Coalition for Corporate Accountability, who will now dive deeply into understanding now how ADR is used in facilitating easier access to justice in the context of business and human rights, as we already have the general concept from Mr. Cyrus of ADR and how its applicability across in settlements of disputes. Mr. Joseph, welcome in giving us inspiring knowledge in how now ADR has been used in business and human rights.
Thank you so much, Praise God. Good afternoon, colleagues on the call. My name is Joseph Byomhanji. I'm an advocate of the Ugandan Bar and a member of the East African Law Society and a business and human rights practitioner. I'm very happy to be sharing with us the potential of alternative dispute resolution in facilitating easier access to remedy, particularly in the context of business and human rights. I will just request Simon to stop sharing screen such that I'm able to also share. And have this discussion. Let me just share my screen. I don't know why the slide is not coming on, but anyway, I can continue to speak to the potential of alternative dispute resolution in facilitating easy access to remedy, particularly in the context of business and human rights. And our colleagues on the call know that business activities, in as much as they have positive impacts like providing us employment and paying taxes, they equally have negative impacts. And it's on that end of negative impacts that we need to explore the possibilities of having alternative dispute resolution mechanisms in facilitating access to remedy. Businesses in their operations affect host communities, that's the communities hosting them, then the people they employ, or what we call the workers, the labor force, and then those in the value and supply chains. And in many ways, there are always disputes arising either amongst the workers or between the workers and the business, or with the host community, or with the people in the value and supply chain. So Simon has ably shared with us the various types or examples of alternative dispute resolution. And he gave the examples, including mediation and arbitration, which can be employed in addressing these disputes. It's important for us to share the importance of alternative dispute resolution when it comes to resolving business and human rights conflicts. And one of the greatest importances is that ADR, or alternative dispute resolution mechanisms, are more accessible. The processes of ADR are more accessible than the court systems, particularly for individuals from disadvantaged backgrounds or what we call the vulnerable communities. They often involve less formal procedures, as simple as a letter or an oral complaint. You can kickstart the process. And that is not the case when it comes to the formal mechanisms. I understand the South African Law Society audience is most conversant with the formal judicial mechanism, and certainly an oral complaint may not be entertained. So that's the greatest advantage of ADR when it comes to resolving business and human rights issues, the point of accessibility. The second crucial aspect is one of empowerment of the victims. The alternative dispute resolutions allow victims of business-related human rights abuses to engage directly with the resolution process. And most often when it comes to the traditional judicial mechanism, the process is largely driven by the lawyer, in as much as they have instruction from the clients, who in this case we are terming as the victim. But in this case, when you employ the alternative dispute resolution mechanisms, then certainly you're able to have the victims in the driving seat. And so that participatory approach in many ways empowers them and gives them a voice and agency in seeking remedies for the grievances that they have against the businesses. The other thing we've noticed when it comes to importance of alternative dispute resolution mechanisms in resolving business and human rights disputes is the aspect of efficiency. Alternative dispute resolutions often lead to quicker resolutions compared to the traditional litigation. Many of us know of the challenge of case backlog. In Uganda, we have a business and human rights case that has spent in the traditional justice system over 22 years, the Kaweri Coffee case. This is not something you'd find in the alternative dispute resolution mechanisms. So that efficiency is something that would be beneficial both to the businesses and also to the victims that would be having disputes with the businesses, so as to ensure that there is amicable settlement of the dispute, and then both the businesses and the victims are able to progress. The fourth aspect looks at flexibility and tailored solutions. Because of the participatory nature, there is a lot of flexibility, and then the solutions are built from the engagement with the parties that are aggrieved. The ADR processes can facilitate creative and tailored solutions so as to ensure that the victims own the solutions to the dispute that they are having. And then lastly, when it comes to me speaking to the importance of ADR, it's really to speak to the fact that it complements the formal processes. It complements the judicial processes. In the civil procedure in Uganda, now it's a requirement to first undergo mediation before you proceed with the civil matter. And most of the cases have been resolved at that level. So when it comes to the context of business and human rights, we look at it as a complement to the formal traditional judicial processes. The key components really around effective alternative dispute resolution mechanisms when it comes to resolving business and human rights related disputes include the aspect of design and implementation. The design of ADR mechanisms should incorporate the principles of legitimacy, accessibility, predictability, rights, compatibility, equitability, and transparency. I'm going to give an example. For most of these funded projects by international finance institutions, they require that they have project level grievance redress mechanisms. And so in designing those mechanisms for such projects, it's important that these aspects that I've just mentioned are taken into consideration so as to ensure that in case there are any abuses along the way, the victims are able to engage these mechanisms and ensure that they get redress. However, the discourse of business and human rights has a power aspect. Most often, the companies have much more power. There are instances of corporate capture. There are instances of revolving door where they get the duty bearers. For example, we have a structure of district labor officers in Uganda who are supposed to manage the employer-employee relations at a district level. But then there have been reports that some of these district labor officers have been co-opted on the payrolls of companies operating within their jurisdictions. And so when workers have complaints, then they are not able to attend to them with the due processes. So there are very many challenges in as much as we've talked about the advantages of having alternative dispute resolution mechanisms coming in to resolve business and human rights related disputes. But there are also significant challenges that we have to be alive to so as to navigate the complementarity of the ADR mechanisms to the formal process. The first obstacle is what I've classified as the power imbalance. One of the most significant challenges in alternative dispute resolutions is addressing the power imbalances that exist between corporations and the victims or claimants. In cases involving large corporations and an individual victim, there can be a substantial power imbalance, and that disparity in many ways may undermine the effectiveness of the alternative dispute resolution mechanism, as the vulnerable party may be pressured or coerced or subjected to duress to accept unfavorable terms. So that's something we have to watch out for when it comes to employing alternative dispute resolution mechanisms to address business and human rights related disputes. The other aspect looks at the aspect of inadequate for sometimes the alternative dispute resolution mechanisms are inadequate for the serious violations. They are gross human rights violations that are occasioned by business actors through the conduct of their businesses. And so it may be in the interest of the complainant or rather the victim, but also the broader public to benefit from this complaint being resolved by the traditional dispute resolution mechanism, such as a court, such that it's clearly pronounced that such an act or omission by a corporate actor amounts to an abuse of human rights. So that spillover effect to the public is greatly emphasized through the traditional mechanisms which may not necessarily be the case if it was subjected to the alternative dispute resolution mechanisms. So that's something we also need to watch out for. As I conclude, it's true that alternative dispute resolution mechanisms present a promising avenue for enhancing access to justice and remedy when it comes to resolving business and human rights related disputes. Its effectiveness is contingent upon addressing the inherent challenges, such as power imbalances and the nature of violations involved. Thus, integrating alternative dispute resolutions within the broad framework of remedies alongside the judicial remedies may provide a more comprehensive approach to achieving remedy and ensuring accountability in the discourse of business and human rights. Thank you.
Thank you very much, Joseph, for that elaborate presentation on how business and human rights can use ADR as a form of obtaining the remedies one sought. And as well stated that the most people who face this or are victims of violations by our corporation are the vulnerable groups, where specifically we can also link it to the community members who are hosting this organization. So with that and with that conclusion of the importance of ADR in resolving these disputes, we are going now to welcome Ms. Rebecca Wangui, who is going now to take us to practical insights and examples to demonstrate now how ADR has been used effectively and utilized to resolve dispute and mitigate human rights violation in business operation. Ms. Rebecca, welcome.
Thank you very much, praise God, and my able panelists for expounding on the topic of the day. As you have correctly put it, praise God, my role is to look around and expound on the practical insights and examples to demonstrate how the alternative dispute resolution is being effectively able to resolve some of this dispute and mitigate the human rights violation. From the onset, when I was listening to my colleague, first Cyrus of our Kenya National Human Rights Commission, and now to Joseph, who happens also we sit together at the East African Law Society, they have really expanded on this principle whereby if you are talking about access to remedy, which is a right, that the necessity for parties to be able to be at par in terms of their powers, in terms of accessibility is what would make, and it's what that the actual, the business and human rights fraternity is trying to look at, in the sense that while we are talking about alternative dispute resolutions on one side being very accessible, efficiency, empowering the victims, you will also realize practically is a tall order to actually talk about how mediation is helping, how negotiation is helping, and simply is because of that nexus of the communities who are more vulnerable vis-a-vis large-scale investors in a country. You will realize that most of the time when we are talking about business and human rights conversation and discussions, we don't talk about them from a scale of, you know, a local company came and did 1, 2, 3 things. It's normally in large-scale investments. So that time we're talking about the public-private investments that we have seen very rampant in Africa, for instance, in this side of the world. I had Gabriel say that Kenya is a Silicon Valley. So what you're seeing is that the global south is now, you know, it's now an epitome for so many of these foreign investments. And so you find that while Cyrus spoke very well that access to remedy is a right, it's also very important, and I know that is something that all of us as practitioners of the law understand, that the prerogative and the initial custodian of guarantee of that right is the state. Now, when you put the state to be able to guarantee the rights, and here comes what we are talking about now, large-scale kind of business operations where a statutory body, by that I mean maybe a ministry of a government in a particular country, has come in, they have, they have negotiated an agreement, and that agreement is supposed to come and probably forcibly evict a huge group of people so that a particular project can take off. You cannot begin to see when you say that, when I start by saying my observation, you'll understand where I'm coming from. It's not that I am against alternative dispute resolution, but if there is a clear imbalance and a clear haphazard way that needs to be resolved for this mechanism to work. So my quick observation into what we're talking about in my role is that, yeah, ADR is very effective. It is even anchored in our constitution, in the Kenyan constitution, Article 159, Sabbatical 2, has been very much taken into consideration by our current sitting CJ and our previous CJ, and they're doing everything they can to promote the different mechanisms that Cyrus and Joseph have spoken about. But I'm here to also say my observation, as I'm also doing my research on the area, is that mechanisms are here to be grounded and realized when it comes to business and human rights operations. And by that, I put a nexus and a pointer that we're talking of this large-scale multinational corporation that bring about what Joseph was saying, whereas we're talking of investment, there are very negative impacts that come with these corporations. So then at the global level, so you have the global institutions of the human rights institutions. We have the national human rights institutions, like what previously the previous employer of Cyrus, that is our Kenya National Human Rights Commission. You have local and international NGOs, media, communities themselves trying to work around trying to work around the ADR framework that we have. But from the onset, the kickoff of it, while, let's say, let me give an example because I'm in Kenya, so I'm a little bit abreast with what happens. So while we have Kenya National Human Rights Commission, which is our National Human Rights Institute, mandated with the work to investigate, mandated with the work to ensure that human rights are being respected, promoted, and everybody's enjoying the same, their power and their mandate is limited to a particular government entity being able to guarantee that. So you'll find that they will be doing a lot of investigations, they'll be doing a lot of inquiries, they will do a lot of documentation, just scoping out what is happening. So if a community is talking about maybe mining activities in their area, it will be the duty of this National Human Rights Institution to do so. But as and when they're able to actually now be able to come up with the reports and all, they are limited to the extent of how they can guarantee those rights. Yes, there will be some indication because when you're putting this foreign investor to task, you are letting them know that actually this is not just a media frenzy. This is not, we're not just highlighting this matter, it's not going away. So when they see that a huge public inquiry has been made, of course it puts the human rights violators on the spot, and they're able to bring about what my friend Cyrus was talking about with Kakuzi, what Kakuzi has tried to do. And of course, I beg to differ respectfully, because most of this, and I think Joseph also alluded, they are tick boxes. So they know that they're supposed to secure the reputation in a particular country. I'll give an example. In Kakuzi, we have Kakuzi, but then we have their parent company in the UK, Camilla. So they have all these violations of human rights, and for them to appear, of course, to protect their reputation, protect their much investment in the country, they'll appear like they're obliging. That doesn't necessarily mean that in that case, what, for instance, Cyrus was talking about, the internal mechanisms, grievance mechanisms are actually working. I do not like the classic example of Kakuzi. My law firm is actually involved. It is involved now in trying to begin to adjudicate the very historical land injustices that the community around Kakuzi have gone through for very many years. And you will realize, even I was looking at it, and what they happen to do with Kakuzi, as I come to the practical examples, I just happen to mention it because it's one of the notorious cases in the region. When they realize that, for instance, an organization is coming after them, they will quickly go to court to litigate. And so the latest action they had was they withdrew a petition that they had filed against an NGO, making an inquiry on the violations that they had around the communities, and that involves misuse of the local administration, police, arresting communities, rape cases. I mean, very gross violations of human rights and freedom. And you find that they are always operating and working in cahoots with the state agencies. Now, in that case, when they filed the petition, to silence, because it was a strategic litigation. It was the local commission, Human Rights Commission, had gone into investigate and try to assist the communities. The Kakuzi legal team now filed the petition. Immediately, what they did, they again withdrew the petition because it's a way of telling the this commission to shut up, and then they sort of now proposed mediation. Okay, mediation is an example of alternative dispute resolution. But then they go ahead and say that the mediation has not worked today. That is up to 2021. Of course, somebody in the team can, appraise me or, update on the matter. But the last conversation that is out there around Kakuzi is that after they withdrew the petition, they sought mediation, but the commission was not ready for mediation, because what they were saying is that they wanted evidence adduced in court that is against them, and already that had been done with the parent company in the UK. So you'll find that what Joseph and Cyrus was saying, those principles of what ADR needs to look like and as an access to remedy remains to be actualized, because we're talking of power plays. Yeah, you're talking of communities that have been evicted from their land for very long, and we are talking about a company that amassed so much land. So beyond the land deprivation, you're also talking about the rights, the employment rights, all this, the labor rights and everything else. So so that's why I say, that's why I talk about the fact that if you're talking about ADR, we are yet to get there. And I also believe that jurisprudence is not, it's not developed, or it doesn't grow overnight. So there is some, what I would call some gradual process taking place. And I think this has also been realized by the Office of the High Commissioner on Human Rights, because back in 2014, sorry, I'm not using my slides, allow me to just speak from my notes. Back in 2014, we had what they called the Accountability and Remedy Project app, and it was around enhancing effectiveness of state-based non-judicial mechanisms in cases of business and business-related human rights abuses. So, of course, from Cyrus's presentation, you saw the state-based non-judicial mechanisms. So that also forms part of the ADR. So where we're not all running to court, we're not all running to litigate, but we're looking at what are these avenues that we can use to quickly report a matter, investigate the matter, and bring it to a conclusive close where the violation is also remedied. And they acknowledged when they started the project as a United Human Rights Agency, they commenced this in 2014 with the aim of delivering credible and workable recommendations for enhancing accountability and access to remedy in cases of business-related human rights abuses. They also acknowledge that the mechanisms may take different forms. So, for instance, we're talking of mediation. What form of mediation are we talking about? Here's the community again, by virtue of what they're going through, their violations and everything. Remember, for any form of mechanism to come to its fruition, people must be together. So these are people already violated, their rights have been abused, and people have been abused in different ways. So even bringing them together, if there is no NGO, or because that's normally what happens, you either find a local NGO that tries to organize these communities so that they can speak in one voice. So what they acknowledge, what the United Nations acknowledge, is that these mechanisms may take very many different forms. And as a result, there is a lot of haphazard legal and institutional development in some jurisdictions. So when you're talking of serious or complex matters like Kakuzi, the matters also in the region, in Uganda, Tanzania, then you find that for such mechanism to operate, and whether it's, they may not, and we are not talking about mechanisms just fitting in an international standard, but we're talking about a mechanism that is actually working for the communities, because we know most of the times, I mean, unless you come across a company, a company that is saying communities have violated their rights, it's always these foreign investors, these large-scale investments, these public-private investments that actually violates the rights of the local citizens. So around that, let me go straight away to the particular examples that I came across. One was this one in Australia. I'm sure majority of you are aware of that. The Australia and sexual harassment cases. Now we're going to the practical examples. And in that, this was an example of a state-based judicial mechanism, because here we have the local Australian Human Rights Commission that conducted a national inquiry in 2018 over the rampant sexual harassment that was in workplaces. So they actually documented, they investigated, and they came and they got to know that so many of these sexual matters were they were rampant in the information, media, and telecommunication industry. And what was also very alarming is that 1 out of 3 people had been sexually violated in the last 5 years. So the inquiry began in 2018, and within those 5 years, 1 out of 3 people had reported. So what the national inquiry was doing, the commission was doing, was to open up for people to come in at an individual level, come and declare if you want to submit, if you want to file a complaint and all that. And what was interesting, over 170 submissions were made to the inquiry. But it's very important to know now, because now we're talking of very gross level of human rights violation. So in this particular one, where we're talking of a form of ADR, you're coming in, it's a national inquiry by a commission in a country that is mandated to investigate, report, and ensure that the human rights of that particular country are respected and promoted and protected. And so you coming in and you have the individual complaint that you have given to the commission. But the commission in this case, what they were trying to do is to ensure they come up with a systematic policy and legal direction on how this matter was going to be resolved moving forward. So while the individuals may not have gotten a remedy by themselves, so for instance, if it was a particular person at a particular workplace, even if they did not get the direct remedy as an individual, the thing is, the inquiry by the commission was a classic example where a systematic response and remedial action was taken at a broader level and not individual. So that's a classic example where, you know, a commission tries to look at something wholesome. So the individual complaints are looked at from an inquiry angle, and the government acknowledges that this is a national disaster and we need to sort it out. So I believe there could have been remedies, because no employer want to be caught up in this in these violations. The other one is another example. Again, it was by the local National Human Rights Institute in Colombia. I'm sure majority of you have come across this Quimbo hydropower case. And in that, we had the hydropower very mega project that was located next to their very beautiful river called Magdalena River, which was declared a reserve by UNESCO in 1979. So for sure, when UNESCO comes in your country and seeks to reserve something, then surely that is of state value. But then we found the company just came around that place and they used the water and everything to produce this high voltage power. The company was licensed in 2009, displacing over 17,000 people around that Magdalena River. Now, the resettlement, of course, is not going to be voluntary, because here is, again, like I say, most of these people, they come in through government. So it's not a foreign investor who has decided out of the blue, so let me go and help Kenya. most of these projects, we all know they're not really for public good. There's something fishy. I think Joseph has said some people are in people's payroll. This particular project was very much supported by the national government. So while the federal government was making a lot of, inquiries and trying to seek out to handle the matter, the national government was there, was the gatekeeper. They had media, they had NGOs, and so what happened was, because of this outcry, the commission was able to bring all these stakeholders together. They were able to understand that there's not, they will be able to report, they'll be able to put in a report and all that. But for this to continue to come to a halt, for the remedy, for the communities to be to seek adequate and just compensation, all these stakeholders needed to be on the table. So the resettlement began in 2014. But again, a classic example where you have involuntary resettlement of people. People think that you can just flag somebody from a parcel of land. Remember, it's access to justice. The land that they know, take them elsewhere, and the place you're taking them, there is no water, there is no health facility around there, there is no education facility there. So while the company thinks they have resettled, they think they have compensated the communities, that is still not the case, because those who were settled, they still have not enjoyed the resettlement, because where they were taken, most of the time, you will bear me witness, it's never a place that is habitable. If anything, you're given 10 times worse than you found. Again, even the process of owning that parcel of land becomes now is a communal matter until everything is sorted out. So they don't have title deeds which they can use for their collateral needs or whatever. So again, that becomes an issue. So, but then what was good about the Colombia National Human Rights Commission in this matter is that there was an opportunity to pursue different approaches of addressing the violation. So they were able to deploy mediation. They were able to do so much research. They were able to document all that the company had done against the communities. They were able to handle the complaints and thereby bringing in a combination of those non-judicial avenues to remedy. So it's not all blame, of course, because, and then you realize that when such things are also brought to the fore and there's a seriousness and consistency, and perhaps the commission has put in money, however expensive it can be at times, definitely the violators always have a way of pushing back by stating that they're going to handle immediate issues that they can, and they will, phase out all these issues that they've been doing to the communities. Now in Kenya, we have again, this was done by the Kenya National Commission on Human Rights, where they were talking about, they were looking into, again, a public inquiry of the mining activities in the county of Taita Taveta, which is at the south of our country, and of Kenya. And this started in 2015. And from the report, the commission says that, as much as we're saying, yes, there's efficiency, there's what, it is also expensive. It's an expensive venture because you have to put in focus group meetings. You must also go, you must ensure that all the communities in a county like that is vast. Everybody has been heard. There is public participation. So apart from just it being an expensive venture, there is also time consumption. So it took them 2 years from the time of the inquiry to the publication of the report. You see? So again, it's a balance. How do you strike the balance? How do you ensure that when you're saying these non-judicial mechanisms, and most of the time you realize all the time, it's the commissions, it's the national commissions who are the forefront, because at least they have the resources that they can put in there, but not much they can do if just one particular area has a lot of that. And of course, again, the allocation comes from the national government. Well, and again, the recommendations that are normally coming from these national human rights institutions also take long to follow through. I mean, this is maybe a policy directive, it's a policy ask. Before you can get in the political, social, and economic interest, it's never that easy, because it's vested and competing. We are talking of competing interest here. So before you can get strike a deal, that can also take quite long. But what was also interesting in this, as a result of the inquiry, few individuals whose land had been invaded and mining activities were taking place had their land restored back as a result of this public inquiry. So it's not, again, it's not all that gloom. There's some positive that comes with it, because now you're putting all the state statutory agency to task on what they're actually doing, and also putting them to let them know what are these agreements you have signed, closed. Most of them, they do not want to disclose to the public, but we all know that when it comes to mining, that's a national treasure. So why do you want to put those kind of agreements non-disclosure, So yeah, and in this particular case, we had also, because there was the issue of environmental degradation. As a result of that inquiry, we had now the particular agency, statutory agency, Kenya Wildlife Service, Kenya Forestry Service, all of them, they are committed to look into that environmental degradation. And then overall, the communities reported significant improvements in the sector. There were now reduced human rights, violation. Okay. I would want to touch something around mediation as an example, because
Ms. Rebecca, please wind up.
Okay. Allow me also, sorry to talk about the Kenyan context, but at least one of the things that our current CJ is doing, and I think is continuing to do, is we have this what we call the court annex mediation. So what it is doing, it is introducing. It has introduced the new court annex mediation rules 2022 has provided for private mediation agreements. So what then it means is that as a lawyer or as an advocate, you don't need to have had your case in court for you to pull it out or for a tribunal or a court to recommend it for mediation. So if the rules can allow you to go quickly to private mediation agreement, where now you organize your community. If you're a lawyer representing community, you will find that majority in this call, you're unlikely to really, but you're unlikely to really represent a corporation. Most of the time we're on this other side of representing communities that have actually been violated. So what do I mean? I'm saying, even as we think through, let's think through around, because 1 minute you may not be able to represent a corporation, then tomorrow you're representing a company, a community. So it's a matter of striking the balance, and of course it comes down to individual choice. So the reason I'm saying that is, while all these remedies are available, there are also particular nexus and factors that come into play. I was going to talk about the Ugandan, but I think that one was sorted, the oil agreement. I think the AG was able to, as a result of pressure, again, he was able to declare that some of these oil agreements with Total Energies to be disclosed in public, which again, if there are violations or whatever, then you'll be able to know whether the Total Energies are actually in line with the business and human rights framework. So yeah, I had quite a lot, but that's all I have for now, and I will come on question clarifications on the matter, and also look forward to hearing from you. Thank you.
Thank you so much, Ms. Rebecca, for that extensive dive into the practical experience and the relevant examples of situations where we see violations arising from issues of business and human rights. And one of the examples you gave us on the relocation or displacement of the community and how they suffer after the fact. So as we had the different panelists speak, it is time now to welcome for questions, but also comment. As initially said, this should be an interactive discussion. So I'll welcome for any comment, any contribution to gain experience also from other countries of the situation ongoing and how ADR has been used to ensure to settle disputes on business and human rights. As I will welcome people to speak, but I'll also read through the Q&A chat to see if there's any comment or questions. If you have a question, you can raise your hand. And before Joseph, you speak, I'll first read, because there's a question posed to you in reference to the situation or for a success story. And so the question rises, if you have any success story of a community which has been empowered in dealing with where the issue of bias is usually problematic, and if so, how was trust hedged to transcend this bias? The case of Total Energy and ECOP. Welcome, Joseph.
Thank you so much, praise God, and Michael that has asked that question. I'm going to share with us a success story that the Uganda Consortium on Corporate Accountability has worked on with the community in Kabolwa. Kabolwa is a place in Bulisa district that's in the Albertine Graben. And Kabolwa community was affected by a feeder pipeline to the oil and gas project activities that are going on in Tilenga and at Kingfisher. So there was a dispute with regard to compensation and land ownership. And what we did was to bring the duty bearers, to bring the corporate actors under the joint venture partnership and the community in one room for a series of engagement to be able to discuss this issue. This was a precursor to us having separate meetings with each of the groups, the communities, to appreciate their concern. Then the company, the joint venture group, that's Total Energies, CNOC, and then the government agencies responsible, the regulator, the Petroleum Authority of Uganda, the Ministry of Energy and Mineral Development, the Ministry of Lands, Housing and Urban Development, and then the Ministry of Gender, Labor and Social Development. Once we had gotten reports from each of the separate meetings, then we were able to bring all the actors in one room to discuss the issue, and the 9 project-affected persons were adequately compensated. So it's one of the success stories we can share, but it came from a result of building that trust to be able to guarantee to them that they are going to be heard. Currently, we have also what I expect to be a success story going on between the Paten clan in Pakwach district in West Nile, Northern Uganda. They are hosting an irrigation project that is funded by the African Development Bank, and they have some disputes with regards to consenting how much land should be given to the project. So we are working with the Ministry of Water and Environment. We are working with Pakwach District Local Government and the community structures to be able to have this series of engagements. And by next month, we expect to now have the first joint meeting where the communities, the government agency responsible, and the African Development Bank Country Office are going to be in one room to resolve this dispute. So those are the success stories I can share, but it comes as a result of building trust and guaranteeing to colleagues that their interests are heard, but we need to find the resolution to the dispute that they would be having.
Thank you, Joseph, for that and giving us a practical experience of the situation in Uganda. I will pose another question to any panelist who will be ready to respond. And this is the question from Michelle, where she would like to know more about ADR resolving cross-border business disputes. For example, a company in Kenya and a company in Rwanda doing business, and a dispute arises out of it. And also, before the panelists go ahead to respond to that, I'll welcome Mr. Cyrus to respond to the question posed by Michael. If there are any lessons we can learn from the Kenyan National Commission for Human Rights on perspectives are most valuable in terms of empowering NHRIs to act in issues of violations of business and human rights. So I'll first welcome Cyrus to respond to that on the Kenyan perspective. Then I'll welcome Ms. Rebecca and Mr. Joseph to respond to the issue of cross-border disputes.
Thank you very much, praise God. Wangui has already highlighted some of the examples, but I'll just weigh in on the same example, the public inquiry. And public inquiries, they may take time, but at the end of the day, when you realize results, you are very happy. We may not attribute 100% the results to ourselves, but there are various other people who contribute to the success of the inquiry, the implementation of the recommendations of the inquiry. But I just wanted to highlight the fact that from the findings in the Taita Taveta inquiry, the issue of the land degradation and the condition in which the miners were leaving the lands is currently being addressed. There's a committee that is looking into how best we can decommission mining sites, and there are guidelines that have already been developed through a very participatory process. And these are some of the concerns that the people raised when we were having that inquiry. We also had done, when I say we, I mean the Kenya National Commission on Human Rights, had done a public inquiry way back in 2005, looking at salt mining and how it had affected the communities in the coastal area of Kenya. There was an audit 10 years or more than 10 years after the inquiry, basically looking at what has changed, what are some of the recommendations that have been taken on board, what is the progress in terms of the implementation. And whereas we may not be where we wanted to be by the time of the audit, at least there were some notable changes. Some of the issues had been addressed, some of the labor-related complaints had also been addressed. Currently, we are finalizing a public inquiry that is looking at the impact of business operations on the rights of indigenous people in Kenya. And we equally hope that these will translate into some practical enjoyment of human rights by the communities that are affected, by the communities that may not have the muscle to litigate. So depending on how you look at it, maybe not immediately, but in the long run, there's a lot that you can achieve. And that is where I was speaking to the fact that some of these mechanisms look beyond the dispute that is presented, but also look at how best those disputes can be avoided in the future. We've also supported different communities that had lodged complaints with the Commission. I know of cases where mediation has been successful. They've been able to record and sign settlement agreements that are enforceable in court. Our civil procedure process recognizes the adoption and enforcement of private settlement agreements that are conducted by parties outside the formal court-annexed mediation. That's what I wanted to highlight. Back to you, Praise God.
Thank you, Cyrus. Thank you for highlighting that. And I'll welcome either Mr. Joseph can go first or Rebecca in response to the issue of how ADR has been used in resolving cross-border business disputes, where particular companies, either maybe from Tanzania, but the dispute has risen in, let's say, Kenya. So how is it used? And here we can also, I can welcome the panelists to also link it and how we can also use the East African Court of Justice in its mandate in settling matters through arbitration. Welcome.
Okay, mine is very minimal, but then at the international level, with the working group on the United, the guiding principles on business and human rights, our working group in itself, together with the Human Rights Council, and the resolutions that the Human Rights Council has actually passed over time, there is recognition that states to work through relevant intergovernmental processes, because they realize that some of these companies, of course, they have the parent company somewhere and a subsidiary company there, and in another country. And so in this case, I've seen the question by Michelle, maybe Kenya, Rwanda, it could be anywhere in the world. So there's recognition of efforts around that, but it then takes, like I had clearly put it, when it comes to now practical insights, you are not going to find an individual wakili or a lawyer somewhere, most of the time fighting for these communities, is normally the local international NGOs, because they have the infrastructure and the administrative mechanism to do so, or an institution somewhere, like these independent commissions. That's normally how these matters are adjudicated. So in that case, if I was to give an example like the Kakuzi one, the parent company is in the UK. And so what had happened is that there is a lot that our local NGO was able to prove right in the UK, because of course they know the infrastructures are there, accountabilities are there, and transparency mechanisms are there. And it was still relating to the very same matter here in Kenya. So our local entities here chose to go to the UK because they felt that is where access to remedy would be. And as we're speaking, of course, you know, everything is a process, but it is something that is doable. It is something that most lawyers, most institutions do explore, and it actually ends up being very effective in the sense that if you have decided to have a subsidiary company, maybe you're from where you've come to the global south, and you have a company that is, you know, in broad daylight violating these rights, and you're somewhere in France, and you're, you know, as a country, as a state, you're saying that you have, you respect human rights, you're also a member within the UN. Of course, no one wants to be held in that regard. So when it comes to all these risks, they have to mitigate. And so these cross-border issues are very many, they're rampant, and any person who knows how to handle now, it should be, it's just a matter of strategy. Where do you go? If the local parent company, or rather let me call the company entity that is within your jurisdiction, is not listening to is not even bothered around just responding, even just having a response towards a complaint, then you can always raise it up with their parent company out there. So it is being done, Michelle, and very many people are exploring, and it has ended up being very positive, because it's as a result of that what you had Sarah saying, that now we have Kakuzi developing grievance mechanism within their, you know, the institutions, within Kakuzi now in Kenya, to be able to start addressing that, and that it's actually in public domain. But whether that has transpired, again, it's a process, because like I said, we're involved in a matter as a law firm, and we're not on the side of Kakuzi. We're on the sides of communities. And as early as last month, we knew not much has been done around these violations. But yes, that's a very great avenue. It does work. It puts pressure. It puts things. And most of the people, there'll be boycotts. You know, if you're doing something, you know, growing coffee, and people get to know that actually this was a product as a result of abuse of labor rights, many people boycott in these first world countries, we call them. So yeah, it is being done.
Just to weigh in, though a bit theoretical, not a live example, but I know for a fact that most of the times when these businesses are negotiating, they would agree beforehand on the dispute resolution mechanism. Would they resort to arbitration? Where would the seat of the arbitration be? What law would they use? And we've seen cases where, especially where multinational corporations are involved, they would beforehand have that in the agreement or in the cooperation agreement that they're engaging in. So it's not so hard to find. The lawyers have already thought through this, and they've provided for how best any dispute that would arise would be resolved. Others would empower, for instance, the Chartered Institute in Kenya to choose the arbitrator. Others would provide for a mechanism, a clear mechanism on how to go about whether it's mediation, whether it's arbitration, or whatever modality they are thinking through. So Michelle, to answer your question, it is possible and it is true that these disputes occur, but parties can think beforehand and they can consider what mechanism they would prefer before they even get to that point, if they ever get to dispute to that extent.
Thank you, Cyrus and Rebecca. And just to add the East African perspective, the Treaty for the Establishment of the East African Community anticipated that disputes could arise, and so elaborated a dispute resolution mechanism. Article 23 of the treaty establishes the East African Court of Justice as a judicial body responsible for adjudicating disputes where the jurisdiction is bestowed on the court by the treaty. So if the dispute is in East Africa, the jurisdiction squarely could enable us get there in case the lawyers and parties have not stipulated where they want the arbitration to go. And commercial disputes fall under the jurisdiction of the court. The East African Court of Justice has jurisdiction to arbitrate disputes arising from an arbitration clause contained in a commercial contract or agreement in which parties have conferred that jurisdiction on the court. So even at the East African level, we have that mechanism possible. And between states and companies, I could share the example of Uganda and the Heritage Oil Company. We had that dispute resolved in London, where the government of Uganda took on a company that didn't want to pay a certain tax and were able to go via arbitration, and the tax was paid to the government of Uganda. So the dispute could be either way between a state and a corporation and a corporation, and the alternative dispute resolution mechanisms are always available to resolve that issue. Thank you.
Thank you so much, panelists, for tackling that question. And thank you for giving us also the perspective of the East African Court of Justice and how we can take matters before it that involve commercial disputes. I see Mr. Shukuru's hand is up, so I allow you to speak to if it's a question or comment or contribution. Welcome. Please unmute. Shukuru, if you're speaking, we can't hear you. You're still on mute. Okay, as Shukuru is still figuring out how to unmute, we can, if he's unable to unmute, please, Shukuru, can you type your question in the Q&A or directly in the chat so that we can read it out? As we're still looking towards participants, I'd like to also pose a question to the panelists. And this is on issues of transparency within the ADR. And as the panelist has clearly stated that ADR is one of the mechanisms that is less formal and that most of our community members can directly access it. What role does transparency play in ADR in related to issues of business and human rights? And how can it be ensured without compromising the confidentiality that is around it? It's around the ADR or characterizes ADR process. And before I welcome the panelists, oh, okay. Since Shukura has already typed that his question is addressed. So I'll pose that question to the panelists on the issue of transparency that plays around ADR, specifically knowing that it's one of the mechanisms that is less formal compared to what we are used of the normal judicial system around. Since the last speaker was Joseph, I can welcome him to go again. Joseph, as you're unmuting to respond to the question, I'll read out another 2 questions posed so that as you respond to the first one, you can go ahead in responding the other 2. We have a question from Baltazar Kitundu, and it goes on: how does ADR work when the dispute includes criminality? And the second question is from Hanning. And what advice would you offer to a person who is passionate about ADR, and any career opportunities that you can recommend? Welcome, Joseph.
Thank you so much. I had the last 2 questions. I will start with them, then you read me the first question. I think I had missed it. But with regard to how we have ADR work when there is criminality, criminality is largely run by the state. So where there are crimes that have been done, ADR may not offer the ultimate redress, because once it's theft, it's murder, it's anything that falls under the ambit of criminal jurisdiction, the state structure often takes it up. The Directorate of Public Prosecution takes it up, and they are able to prosecute the crime. So I wouldn't advise for ADR to address the issues of criminality. I don't know what the other panelists think about that. Then the second question, career opportunities. True, there are many institutions in the East African community that are available to offer growth in terms of education, in terms of skills, for anyone that is passionate about the various alternative dispute resolution mechanisms. So I would advise the participant who raised that question to pick interest. I don't know in which country they are situated, but in all the East African countries, certainly there are institutions that could harness their growth in whichever alternative dispute resolution mechanism they are interested in, to be able to have the skills and engage, participate in mediation sessions. Usual arbitration is a bit close, but at least mediation you can participate, because some of it happens in open court. So it would be very good to join entities like the Center for Alternative Dispute Resolution to be able to harness your skills and present yourself as a person that is able to support people resolve disputes via ADR. Kindly share with me the first question. I had missed it. I had a technical glitch a bit.
The first question asked on the role. What role does transparency play in ADR proceedings?
Thank you so much. Transparency aids in building trust. For us to be able to use any of the mechanisms under the alternative dispute resolution, as Cyrus shared with us in the earlier presentation, there has to be trust. So to build trust, the parties involved in the dispute need to be able to appreciate that the process is transparent. They need to be able to appreciate that the procedures followed are quite clear, so as for them to have trust in the process. The moment they do not have that trust, then you'll not be able to get a resolution out of the alternative dispute resolution mechanisms, because the mistrust would be created. So the best thing is to ensure that there is transparency in whichever alternative dispute resolution mechanism you've selected, such that we're able to have a concrete conclusion. Thank you.
Thank you, Joseph. Also to respond to Hanning, you can also get career opportunities and also get more knowledge and network with people who do ADR through different webinars that East African Law Society organizes, and also other bar association organizers. I'll welcome Mr. Cyrus to respond to the other 2 questions. What is your opinion on issues of ADR involved in criminality and the issue of transparency? Then we'll have Ms. Rebecca also give her opinion on that.
Thank you. As I had observed, I'm a pragmatist, and I like looking at reality, the way things happen. And every time I go to court, because I sometimes go to court whether to observe or maybe to help in one way or another, I have seen the application of ADR in essentially criminal matters. Think of how many times a prosecutor withdraws a case from the court or from the criminal legal or the criminal justice system, as one may refer to it. There are many times that even the person, the direct victim of the crime who had reported, just shows up to the court and tells the prosecutor, I'm not willing to proceed with this. Practically, if you get to that, unless you have independent evidence that is admissible, that case has almost come to an end. So the prosecutor can hang on to it, but to what logical conclusion? To what end would that be serving? So my straight answer is it depends on the context. I have seen cases where application of ADR, and if I borrow from the Kenyan context, we have prosecution guidelines and there are other policies, and one of the policies is the diversion policy, where besides looking at the criminal justice or the criminal legal process per se, a prosecutor is expected to also look at how best they can apply alternative dispute or alternative justice systems in their discharge of prosecutorial powers. For us, it is clear that a prosecution, one of the many factors that a prosecutor is expected to look at is the public interest. Would the public interest be served more in sort of forgiving or letting go a chicken thief who stole because they were starving, or would they better be served by running them through the entire criminal justice system, and at what cost? For us, I should also point out that we have an alternative justice systems policy, which has been formally adopted and guides the application of alternative justice systems. And the only clear exception where you cannot resort to alternative justice systems is where the law expressly forbids it. For instance, in cases such as defilement, and that brings with it a few other concerns such as the principle of agency. Can the minor be taken to have voluntarily submitted themselves to the alternative justice process? Because at the end of the day, and I think Joseph had spoken about this, ADR is a strictly voluntary process. The only mechanism that I've seen people having no choice to participate is actually in court. Because the moment you are served with court documents, whether or not you participate, the court will find its judgment at the end of the day. And the court can actually coerce you. They can actually send summons for you to attend, either give evidence or participate in one way or another, and like in alternative dispute resolution mechanisms where the parties are the ones in control. So my straight answer would be, it depends on the context, it depends on the crime in question, it depends on the interest of justice, it depends on the particular circumstances of the case. And moving on to the second question, transparency, I cannot overemphasize how important it is. It's very important to share information. I mean, as human beings, we all want to know what is happening to us. No one wants to be in a process where you're just at the mercy of someone else. You don't know what they'll do. You don't know what is likely to happen the next minute. For advocates, the rule of law has been spoken about so many times, and one of the things that it demands is predictability. One should be able to tell that this is what would be punished so that they can order their contact. It is the same thing in alternative dispute resolution, where one needs to know as much information as possible, especially the processes. How can they intervene if at all they feel that the process is not being done or conducted in a fair manner? At the end of the day, when you submit or when you subject yourself to this process, how do you go about enforcing the alternative justice system? I would say to the extent possible, of course, mediation, for instance, is a very confidential process, but it cannot be confidential to the extent that the parties participating in it are limited in terms of the information that they share, because that information can also not be used in any subsequent litigation. So it depends on what you have in mind. It depends on the nature of the mechanism that parties have agreed to submit themselves to. There are those that would be expected to be more wider in terms of the scope of information that they are sharing, more accessible and more open even to the public, especially when you are looking at operational grievance mechanisms. It is expected at the very least that the public would know over and above the parties who would be submitting themselves to such a process. Yeah, and this is the only way to build confidence, and people would be able to use that mechanism when they are sure it is protecting their interest, when they are sure the process is fair, when they are sure the outcome will also be fair, does not offend notions of justice, and is likely to be enforced. Thank you, and back to you. Praise God.
Thank you, Cyrus, for that explanation. I welcome Ms. Rebecca to also provide her opinion into the matter. Welcome, Rebecca.
Thank you. So to Haning, I think it's a very good question. You've mentioned that you're in Uganda. I would just give a word of caution, be very careful, because some of these institutions, and I don't think it's very unique even here in Kenya, there are some organizations that actually say that they're offering a mediation course and all that, and then you go back to your equivalent of what you have in the School of Law here, and you realize, sorry, that the institutions that are supposed to accredit you realize actually no, it was mediation in their other language. So I would really recommend that you go down and find out from these institutions exactly where you can do, because like now in Kenya we have the Chartered Institute of Arbitration. It has particular processes that you must follow if you're an advocate and you're not starting from where, and it goes on associate and all that. So yeah, it's another area of practice. And like in Kenya, I don't know about Uganda, but in Kenya you find there are so many advocates, but not very many people venture into arbitration, because again, arbitration is very, very expensive. So I don't know why it's a preserve of a few. But when it comes to mediation, it's also very critical, because the court system as well, I mentioned that the court itself has is promoting mediation very easily. So even as if you're an advocate in Kenya and you've gone in and you've done a mediation and you have been qualified by a certified institution that is recognized within the Kenyan legal framework, you just go there and they list your name as an accredited mediator, and you can find yourself even just mediating on a matter simply because you are in the system. So yes, those opportunities are there. I just request to be proactive and just find out which are the most credible. So because you do not want to waste time, especially mediation. There are very many institutions that say they are doing mediation only to realize it's not accredited. The actual course is not accredited. On transparency in ADR, I would rather speak, for me, I would speak from what I have seen, perhaps communities, and communities, they're in large numbers. So most of the time they will trust an organization, a local organization to handle their matter. They may trust an independent institution in the country, which is not compromised by a government, by a fellow government agency or a statutory body. Their matter may be taken up by an NGO. An NGO is independently operating, it has its resources, so they're not likely to go against the community. So if you're talking about ADR around like the complexity of the matters and the magnitude of the matters you're talking about, because when you're talking about business and human rights, for me, what comes to me is these big corporations against major communities in some remote area or even urban areas in our countries. So their frameworks are there. It's very easy to deploy transparency, because even the people that there was this matter in Tanzania, Loliondo is the minority group, MGI, Minority Group International. It's a very respected land rights organization, NGO in the region. You see, they take the matters even all the way to international entities. So there you're not likely to have somebody being compromised on their end. the issue now comes on this other end. Maybe they choose to move or change their advocates or whatever it is. So I would actually say that there is an opportunity there around that. The only thing is, like in Kenya, we have what we call traditional mechanisms which have been lumped together with arbitration. And yes, they are there. So you find if you're from a different community, depending on your cultural way of doing things, that the elders can sit down and they can deliberate and adjudicate a matter. So if I was to give an example, contextualize maybe a case where maybe rape has occurred, sometimes it becomes very, I mean, it is very, it has happened. Actually, it does happen today where elders will sit and they're told this and this has happened, and somebody is given cows to now and never to raise the matter again. You see, is that justice? Absolutely not. And probably it's defilement of a minor, and probably even that girl has probably gotten pregnant. And so they will resolve it at that traditional angle of it. Then you cannot, you as an advocate, you cannot now say that you have remitted or you have done your very best to ensure that the victim in this particular case has actually done what, has actually accessed the right remedy, and they have been restituted or they have gone through the reparation processes that they needed to be. So it varies. One has to really look at what process you're looking at. In matters also arbitration, unlikely you find, I've had Cyprus talk about the arbitration agreements. Most of the time you find that communities are not really going to go arbitration because it's a very expensive venture, especially if you're talking about an international entity somewhere seated and they have their parent, I mean, they have a subsidiary company in your country. Then you're talking about hiring these arbitrators who are paid hourly, you know? So that's why you find that other ADR mechanisms come in. They are much more favorable even to the community than they would be ordinarily, because unless now, as Joseph and of course himself, Cyrus was saying, you're talking about a corporation, a state company, a state corporation with maybe a foreign company, and they have those commercial matters. That's when arbitration will really come in. But if you're talking of business at the community level, these other mechanisms, less arbitration will be the likely way to go. On criminality and arbitration, again, I think it is also very, it is in context. You have to put it in context, because again, in these other markets, in these foreign markets, it gets to a point where you realize you're not going to get your justice in a criminal matter. Then your advocates, the advocates were very pragmatic. You know, they look at it from an angle, whatever justice I'm able to receive, I receive. So if you can imagine now, there's no way you're going to talk about, you know, arbitration, rape, defilement matters, like we have had scenarios where soldiers have defiled women, and although that is not around, I wouldn't call it business, and you know, that's maybe another angle. But many women in a particular area in our country literally have, you know, multiracial children as a result of rape coming in that particular region. So in that matter, you may realize that is not the way to go. But somebody else may say, okay, these children are there. Can we have fully fledged compensation on how they're going to go ahead and, you know, have the education catered for, have their health facility catered for, their shelter? So again, it depends with the strategy that, you know, open mind, where a scenario happened and the children were born. What next? And the parents love the children. So in that matter, so you're handling, somebody was violated like 10, 15 years ago. And so they have a 15-year-old girl who wants to be now educated to another level. So you may look at what levels or how do you, it will probably not restitute, you never restitute such a scenario, and you never remedy that scenario. But the other things maybe you can do civilly to see what can be, how you can adjudicate such a matter at such particular stage. So that's all I have to say. Thank you.
Thank you so much, Rebecca, for giving us your insight into the matter. And looking that we don't have any more questions or contributions, and also being cognizant of the time, I will give the panelists time now to give a round of conclusion and recommendation on way forward on the issues of ADR as a mechanism for dispute resolution on issues of business and human rights. And I'll start with Rebecca, since you're the last speaker. Welcome, Rebecca.
Thank you once again. I believe this is a timely matter to deal with as a region, as a, as a continent. If we can be able to have infrastructure also that boosts and promote, because most of these violations, you realize, as one of the participants mentioned, they are cross-border. So when we look at how ways of harmonizing, because I think I've had very many people say their constitution has acknowledged this, and also we need to now be able to move from that to a regional level where you're able to harmonize, and where even if a remedy is not given at the national level, you know very well that if you go to the African regional body, that would be taken into consideration, and that would be looked into. So it's a timely matter. We hope to have more conversation, and I want to thank the East African Law Society for giving me this opportunity to share and learn. And also thank you to my fellow panelists and to the participants. Asanteni sana.
Thank you, Rebecca. Welcome, Joseph.
Thank you, praise God. In my conclusion, I would just emphasize that alternative dispute resolution mechanisms are very pertinent in resolving business and human rights related disputes, especially disputes amongst host communities and the companies they host, but also the workers. We hope that more of the trade unions will be able to appreciate these mechanisms to be able to give the best value to their members, who are the workers. I extend my appreciation to the East African Law Society for giving us this opportunity to share and learn and be able to discuss alternative dispute resolution as an alternative or a complement to the traditional redress mechanisms that we are trained to use as advocates. Thank you so much. It has been a great discussion, and I look forward to having more of these conversations.
Thank you. Welcome, Cyrus.
I'm sorry, I was on mute. Thank you, everyone. Thank you, co-panelists. Thank you, moderator. Thank you, the East African Law Society. Allow me to just end by challenging all of us. We've identified some challenges. I think my challenge would be to everyone, what is it that we can do? Because we all have a role to play in enhancing access to justice in our small ways. How can we enhance the effectiveness of all these mechanisms? If it's about cooperation, if it's about implementation, how can we enhance this in whatever spaces that we are in, whether we are serving as advocates, whether we are working in the judiciary, whether we are working as corporate advocates, in whatever manner, I believe that's something that we can all do. I'll finalize by telling a very brief story, very, very briefly, if you allow me. COVID came, it taught us many things. People were working remotely, so after COVID, some advocates decided to meet. And they were joking with one another and saying, oh, you're the worst lawyer, you win this title, no one can beat you, because for the last 30 years, we've never seen you in court and you've never won any case. So these advocates just told them, well, it's okay, I agree. I have never won any case for the last 30 years, but I'm in the corporate world. I don't even go to court. But the people I represent have been doing very bad things, but I've always advised them, and they've started changing. And the billables, or the amount I was making, is actually much more than I would if I were going to court. So the bottom line is, it doesn't matter where you are. It doesn't matter how you look at it. If you look at it from a litigation perspective or from an ADR perspective, we are all contributing in enhancing access to justice and corporate accountability. Finally, I leave everyone with this quote from Angela Davis. And she said, I am no longer accepting the things I cannot change. I am changing the things I cannot accept. Thank you, everyone.
Thank you so much, Cyrus. And we will end with your quote. We see what we can change as advocates in the legal profession in the EAC region. And on behalf of the East African Law Society, I'll take this opportunity to thank everyone, from the panelists to every participant who attended, and the contribution, the comment throughout the webinar. And we welcome you in other organized webinars by the East African Law Society, and also other organized webinars by the Business and Human Rights Committee, so as to see how we can exchange ideas, experiences, and knowledge around issues of business and human rights as the legal profession, so as to enhance and be knowledgeable across the region and to promote cross-border practice within our region. Once again, I say thank you, everyone, and it was good having you in this webinar. Thank you.